Yes, ma'am. Good morning.
Good morning. May it please the Court, Attorney Jacqueline Greenhalgh here for Alyssa Pugh, along with me, Attorney Peter Ettenberg for Alyssa Pugh. Almost 5 years ago, Alyssa Pugh gave birth to a baby boy in the bathroom of her home. She was alone in that bathroom. She was scared in that bathroom, and she was in shock in that bathroom. And feeling her child's foot inside her body, protruding from her body, she did the best that she could. She did the best that any woman could do in those circumstances. And because of that, she was charged with manslaughter and convicted of manslaughter. And I'd submit to the Court that based on the evidence in this case, there was not enough evidence to convict her of manslaughter. And first and foremost, the first issue I have is what caused this baby's death. When you read the transcript, the trial in this case, you'll see that not one doctor could tell you what caused this baby's death. Dr. Niels, the medical examiner, the pathologist, peripartum injuries of an unknown etiology. When asked what was the cause of death, I don't know, unknown. Dr. Roberts, when asked the cause of death, trauma, hemorrhage, exposure, suffocation. It was all a mystery to her what caused this baby's death. Dr. Callery, I can't tell you what caused this baby's death because so much happened that we don't know about. I can't tell you when these injuries happened or what injuries caused that baby's death.
But what matters is not specifically what caused her death, but whether her conduct or failure to act caused the death.
Correct. But there has to be conduct that led to causation that led to the death. And if we don't know how the baby died or what the baby died of, I'd submit at that point there's not enough evidence to convict her of manslaughter.
Well, let me ask you on that. The judge in his findings appears to say that once the mother felt the protruding foot, that she then knew, because she had been in birthing class for her first child, that there was a risk of breach and that there was a substantial risk of harm. Was there any evidence as to whether or not at that point anything meaningfully could have been done to save the baby?
No, there was not. In fact, nobody could testify that if she had called for help, if medical experts had arrived, doctors had arrived, whether the baby would have been saved. There was no evidence to any of that, Your Honor.
So there was no expert testimony that if the call had been at that point in time, this would have happened, and the baby would have been saved?
Dr. Roberts testified to some of that. There was a number of hypotheticals that were put before her. If this had happened and they had arrived at this time, would the baby have been saved? But in his findings, Judge Agnes did not take that into consideration, and as a matter of fact, he specifically excluded it from the evidence in his decision.
Do we know what would have happened if there had been no pulling and tugging, and whether or not, and no one called in to assist, what the result would have been?
We have no idea what the result would have been. Without pulling and tugging, we have Miss Pugh in a bathroom with a baby lodged inside of her. We don't know it's childbirth. We don't know what would have happened at that point.
Breech births.
We can surmise what would have happened with a breech birth. We know that it's as Miss Pugh knew, that it was dangerous, but we don't know what would have happened to her to that baby.
Was there any evidence to the effect that had she gone to the hospital when the contractions started, the baby would have survived?
There was no evidence to that. No one was called to testify to that, and there was no evidence to that. And as far as when the contraction started, when you read the evidence and you read Judge Agnes's opinion, although he finds that he does not believe that she only knew she was pregnant in October, he also says, but I can't tell you when she knew she was pregnant, that the Commonwealth did not present enough evidence for him to make a determination as to when she knew she was pregnant.
But certainly I read his fact findings to conclude that it was a long time before October. It wasn't maybe September, but it was a long time before October.
I don't read it to say it was a long time before October. He doesn't believe that she had her last menstrual cycle, I believe, in September. However,
didn't he say that? Didn't he find that she recognized she was having contractions?
Yes, he found that she recognized that she was having contractions.
Yeah.
However, there's no finding in there that that she knew, since she was having contractions, that she was going to give birth when she went into that bathroom. The only evidence was that when she went into the bathroom, she thought she was having a miscarriage. That's the evidence that was before the judge.
I'm having a little trouble understanding what the record consists of. What went into evidence? She did not testify.
She did not testify.
So the judge made these findings on the basis of the police officer's testimony when the police officer had spoken with her, what she said to the police officer?
Correct. There were 3 separate interviews.
Were there
over
any
3 days.
tapes were these interviews taped?
The interviews were taped. I believe it amounted to 5 hours.
And were there transcripts, or those tapes were presented to the jury, or the transcripts were to the judge?
The tapes were presented to Judge Agnes, and he listened to those tapes.
And those were the tapes of the defendant being interviewed?
Correct.
So that's where he got is there any evidence as to what her physical look was there was in your brief, I think it was, that in her first pregnancy, she had gained 90 pounds. In
Yes.
this pregnancy, she'd gained 15 pounds.
Yes,
She was still wearing her normal clothes. Was that all established? Was there contradictory evidence as to that?
No, there was, and I can tell you, first, Judge Agnes did listen to the tapes, but also the trooper took the stand, and he was cross-examined and direct examination, so there is his testimony as to what happened during the interview. And to answer your second question, the evidence came in that she gained 90 pounds with her first pregnancy. At this point, she had only gained 15 pounds. She had some issues in her first pregnancy. With this, she never felt the baby move. She never felt the baby kick. She had no issues with this. There was some evidence that came in from about 4 witnesses saying that they didn't know she was pregnant. At that point, she was heavier than she is now. But there was one witness that said, I believe she looked like she had a basketball in her stomach. 1 out of 4 or 5.
Did her boyfriend testify?
He did not testify. However, the trooper testified to the fact that the boyfriend was interviewed, and they had been intimate a week, 2 weeks before this had happened in the bathroom, and he had no idea she was pregnant. So there was no conflicting testimony saying that she looked like a typical 9-month pregnant woman.
Mm-hmm.
The only testimony was she knew she was pregnant. She didn't know how far along she was. She knew she was having contractions. However, she thought when she went into that bathroom she was having a miscarriage.
Was there any testimony that was contrary to, I presume she told the police officer she'd had a history of irregular periods and had some bleeding, and the judge disbelieved this, but this was all part of...
Correct. What the judge disbelieved was when she had her last period. I believe she said she had her last period in September. He disbelieved that, but there was no conflicting evidence, and there was no finding by him that he disbelieved that she had irregular periods. She wasn't a regular person, so she would know how far along she was.
Did he disbelieve that it was a menstrual period, or did he disbelieve that she had had some bleeding?
My recollection from his finding is he disbelieved that she was in her menstrual cycle, had her period.
If I could turn you, there are states, I gather, which have imposed a duty upon a mother with regard to the viable fetus, correct?
Correct.
Based on the experience of those states, any reason to believe that the fears articulated in your brief have in fact occurred in those states with regard to the imposition of special burdens upon a mother that interfere with their choices in childbirth?
Not to my knowledge, Your Honor. I think the difference here, which is similar to the Alabama case and the Wyoming case, is that here, Alyssa is in the throes of childbirth and not knowing when she went in that bathroom what exactly was happening. I'm not saying that she hadn't given birth before and she didn't know what it was like to give birth, but at that moment, 8 or 9 years later after her first child, in the throes of childbirth, in those circumstances, We're at a different point here. What else could she have done when she felt that foot?
Was the first pregnancy a breach also?
No, it was not. It was not a breach. However, she did have an episiotomy and some sutures after that.
But the baby was in normal.
The baby was in normal position. My recollection is there was some concern that the heartbeat was dropping when she was in labor. However, they had worked that out.
Do we even need to consider that a pregnant woman owes a duty during childbirth in order to get to the commission aspect of this crime?
I don't think so on Judge Agnes's decision, because Judge Agnes's decision to me says that her acts of pulling and pushing was wanton and reckless conduct. He's not saying that she had a duty to act and she didn't. He's saying that her acts are wanton and reckless, but the definition of wanton and reckless is a reasonable person or the defendant in those circumstances. And when you look at the circumstances and you take away the fact that she had a child 8 or 9 years prior, because each pregnancy is different, and every time you give birth, it's different. So in those circumstances, in her bathroom, alone, scared, in shock, thinking she's having a miscarriage, feeling a foot, what she did was to deliver the baby. That was those circumstances. I don't think you even have to get to the fact that there is some kind of duty to act. However, after reading Judge Agnes's decision numerous times, what he is saying, I think underneath it all, is if you're good, you must get medical help. Because if you're making this decision to have a baby on your own and something goes wrong, now your actions are wanton and reckless.
May I ask, she knew she was pregnant.
Yes.
Did she have an idea of when the baby was due?
No. She thought, the testimony is when she went into that bathroom, she thought she was about 3 months pregnant. Now, Judge Agnes doesn't believe that statement. However, he can't tell us how far along she was. He says, although I don't believe...
I thought he could. I thought it was 36 and a half weeks. I thought there was medical testimony.
No, that's how far along the baby was. But he didn't make a finding, as I can tell you, that Ms. Pugh thought she was X amount of months pregnant. He said, I don't believe that she thought she was 3 months pregnant, but I can't tell you, and the Commonwealth hasn't proven, how far along she thought she was.
Had she sought any prenatal care?
With this child, with this baby? No, she had not.
The Judge Agnes found that most of the baby's brain was missing.
Correct.
Is that as a result of trauma, or was it a birth defect?
No one testified to that, Your Honor. However, the doctors did say that they didn't find any birth defects or abnormalities with the child, so one can only surmise that the brain being missing perhaps was from being put into the dumpster. However, there's no...
Okay. Were there photographs of the child in the dumpster?
Correct.
And were the injuries to the head, or were they?
There were so many injuries. There was injuries, the arm was severed, there was injuries to the head, then there was injuries throughout the body. There was just a number of injuries. And there were specific injuries that Judge Agnes found that he says were caused by Ms. Pugh's actions. However, I'd submit on that point that even the evidence doesn't support that. Dr. Niels was the only doctor that was asked, do you think Ms. Pugh's pushing and pulling on this baby caused those injuries, those specific injuries that Judge Agnes found in his opinion? And when asked that, Dr. Niels said they could have. Not, yes, they did. Not probably. All he said was they could have.
Just a small but clarifying question about the meaning of pushing in the context in which it's been used in the findings. Pulling, I get. Pushing could be a couple of things.
It could be, and there was no testimony to what was meant by
Whether
pushing.
it was pushing bearing down, or whether it was
Correct.
pushing on the fetus itself.
We don't know that. All we know is that in the interview, she said I was pushing and pulling. We don't know whether she was bearing down, as trying to give birth to this child, or whether it was actually just some sort of pulling.
Thank you, counsel.
Thank you.
Good morning. Ellen Lazar-Moore for the Commonwealth. This defendant was not convicted for failing to act where she had a duty to act. She was convicted for her affirmative act of inflicting fatal injuries on her baby by using so much force on his body that she ruptured his liver, filling his abdominal cavity with blood, broke his rib, and caused severe hemorrhaging throughout his entire body, causing his death.
Is that so clear from Judge Agnes's decision?
Yes.
The Commonwealth presented 3 theories. Is it so clear that the judge just ruled on one of them?
Yes, Your Honor, it is. First of all, the Commonwealth actually presented 4 theories. If you look at transcript number 3 and the closing arguments at pages, I believe, 41 through 46, it lays out the Commonwealth's theories. Judge Agnes left out one of those, and the one that he left out in his summary is actually the one that he ended up adopting, which was convicting her on her affirmative acts, not on failures to act. And the 2 of the Commonwealth's theories actually were based upon a failure to seek medical assistance. And Judge Agnes rejected those theories and, in fact, affirmatively found that there had been no proof that seeking assistance would have made any difference.
So in other words, here, a woman who chooses to give birth alone without seeking any medical assistance and finds herself doing a breech delivery is somehow criminally culpable because she tries to get the baby out of her.
Not because she's giving birth alone and tries to get the baby out, but because she used so much force on the baby's body that she essentially crushed his internal organs. And there was testimony from both experts that those injuries to him were the cause of death. Dr. Niels, the medical examiner, said that the manner of death was undetermined, in that he would not call it a homicide. But both of the Commonwealth's experts agreed that the baby had died from these injuries and that the injuries had been inflicted either during or just after the birthing process.
Was there any evidence as to what happens in a breech birth that's unattended? Ordinarily, what the survival rate of babies in those circumstances
There was no
is?
evidence of the survival rate of babies. There was...
So we don't really know what happens when a woman who's giving birth in a breech position is unattended. We don't know what happens to those babies.
Dr. Roberts did testify in general to what could happen, sort of the process, but she said there are a lot of factors that come into play, including the size of the baby, the size of the mother, whether 1 foot comes out, 2 feet come out, when the head is entrapped, where the position of the cord is. So there are a lot of factors that she described that could come into play, and there was certainly no testimony as to percentages or survival or anything along those lines. But again, if you read Judge Agnes's findings and rulings as a whole, he is convicting her for her actions, not for a failure to act.
Was there any evidence as to what, when you say, because there was so much force used that this baby died as a result, was there any evidence, if that's wanton and reckless, of what somebody might do in a situation where you're having a breech birth unattended? I mean, I guess I'm just trying to
No,
figure
Your
out
Honor, and I think...
What makes it wanton and reckless other than not seeking medical attention? Was there any...
Dr. Roberts testified that these injuries to this baby, that you would require a huge amount of force to break ribs the way that this baby's ribs were broken.
This is obviously, it's involuntary manslaughter, correct?
Yes, it's involuntary manslaughter.
This is not intentional.
Well, the acts are intentional. The result is not intentional, but the acts are intentional, and the standard is she intended this conduct, and there was a high degree of likelihood of substantial harm to the victim. Evidence of the severe injuries to the victim The fact that the defendant caused them and the fact that they caused the baby's death was sufficient to sustain the conviction.
I mean, the problem, though, is that, I mean, I don't claim any special expertise, but for a breech birth, even for a doctor to attempt a vaginal delivery requires extraordinary skill and some degree of luck. So are you saying that because she did it poorly, that because she attempted to do a vaginal breech birth poorly, that she can be convicted of involuntary manslaughter as opposed to having it be done better by her?
No, Your Honor. I'm saying that because what she chose to do was essentially crush the baby's internal organs by the amount of force she used on him, that was an intentional act that clearly created a high degree of likelihood of the baby's death.
But the problem that by saying that in answer to Justice Botsford that it was not the failure to seek help that matters, then you're saying that she should have done it more deftly.
Yeah.
And that's a rather extraordinary thing to ask of a layperson in that circumstance, isn't it?
Well, I don't think that in assessing the evidence, viewed in the light most favorable to the Commonwealth, that we normally ask the question, what else could somebody could have done? The court is essentially putting a burden on the Commonwealth to prove things other than what the defendant did.
Actually,
the
what you're
Commonwealth proved what the defendant did, how it affected the victim, that there was a substantial likelihood that the victim would die from this, and that the victim did in fact die from this. Those are the elements of the crime, and they were satisfied by this evidence. And I suggest that if a third person had inflicted these exact same injuries on this baby during this delivery, that no one would question the third person's liability for the baby's death. If a third person had come along and put so much force on this baby that
If a third person had come along and attempted to assist in the delivery but did it poorly, there would be no question that they would do
I
it?
don't think there would be. If a third person had come and grabbed this baby and squeezed it so hard that they ruptured its liver and broke its rib and filled its abdominal cavity with blood and caused hemorrhaging in the head, neck, eye, back, lungs, testicles, that third person would clearly be liable and that no one would be questioning that.
Are you focusing on the level of, well, you really do. You focus on the injury. And are you suggesting it seems to me what you're suggesting is, even though you say that it isn't based on any duty to seek help, that anybody in this position, unless they're very gentle and don't cause any harm, death, is going to be liable, culpable for involuntary manslaughter. I can't really see any other outcome for either the mother in this circumstance or anybody helping. If there's death resulting, it's going to be manslaughter, unless you think that the breech birth is possible without some kind of physical manipulation.
I don't necessarily think that's so. I think that based upon the findings that Judge Agnes made here, he made findings of affirmative acts that caused injuries that caused the death.
So the focus here is on the type of injury.
Yes, because of the degree of force used. That is what the basis of the verdict was. And although the judge did consider the fact that no help was called, that's because you're looking at the circumstances as a whole, what was known to this defendant, and what a reasonable person in those circumstances would do. That is different than saying the defendant had a duty to do this and violated that duty.
But that's just the question. How do we know what a reasonable person in the defendant's circumstances would do? We don't know anything about that, do we?
Well, how do we ever say what a reasonable person in these circumstances would do? That's a question that we ask in the criminal and civil law all the time. There's an objective and a subjective component. It's subjective in the sense that we look at all of these circumstances that were known to the defendant, and then we ask, what would a reasonable person in that or we don't ask what would that person do. We ask, would a reasonable person have known that there was a high degree of likelihood of substantial harm to the victim? That's the question in involuntary manslaughter. And here, yes.
And you'd know that, and then you'd do what? If you knew that you're in the midst of labor and it's the baby's in a breech position, and you know that this is harmful, potentially harmful, what do you do other than call help? That's the
there
real
are-
problem here. I mean,
Yes.
because you're saying that she's culpable because she tried to get the baby out herself, and she did it, you know, and in the process of doing that, she injured the baby. She caused the baby to die. What was her alternative?
Well, Your
What was
Honor,
the alternative other than to call for help?
it was not
To
simply...
just remain in labor without
No,
trying to
it was
get
not simply that she tried to get the baby out and she didn't do a good job.
What
If
was
you
it more
read the
than that?
entire record and you look at the extent of the injuries to this baby,
Babies are easily injured.
no, they're not as easily injured as you might think, according to the expert testimony. Dr. Roberts testified to the huge, tremendous amount of force that would have needed to be used on this baby to cause the severity of the injuries that this baby had. She said it would be almost impossible to cause the kind of a crushing injury that he had to break the ribs by just clamping down with hands pulling, that in all likelihood it was more of a compression injury, essentially crushing the baby. So it was not a case of, I mean, I don't know, there are many other things that she could have done, but the question
Such
is,
as?
what did she do?
What are the other things that she could
Well-
have done, other than call for help?
No, yes, she could have called for help,
But
but
other
she
than
could
that?
have also not used this amount of force on a
Aren't you saying
baby.
she used too much force?
Yes.
They referred to it as pushing and pulling, and you're saying she pushed and pulled too hard.
That she used too much force upon the baby, that she inflicted fatal injuries upon him, not just by delivering him, but by the way that she grabbed, and the judge found, he said she used substantial force, she used significant force, she had to clamp down on the baby's abdomen, she affirmatively inflicted fatal injuries upon the baby. She didn't just let him die by not seeking help. She affirmatively inflicted fatal injuries on him.
Well, if she had been out in the woods, 50 miles from nowhere, and her cell phone was dead, and she got into her car once she felt the contractions, and the car died, and she did exactly what she did here, would that be manslaughter?
I think it would be exactly the same if she affirmatively inflicted fatal injuries on the baby by using so much force upon him that she killed him. I mean, he died of the injuries that she inflicted. He did not die because he was a breech birth and, let's say, the head was entrapped and he couldn't breathe. He died from the traumatic injuries described by the Commonwealth's two experts. He died from the injuries she inflicted.
Was there evidence as to, had she not done those things, was there evidence as to how the baby might have come through the birthing process?
Again, only in Dr. Roberts' testimony as to different alternative ways that a breech birth could happen, and they were all
Even in these circumstances, where she was alone?
right. But, she said sometimes it'll come right out, sometimes it won't. Sometimes it'll be 1 foot, sometimes it'll be 2.
Did she talk
Sometimes it
about-
will be this, sometimes it will be
Did she
that.
talk about what happens when it doesn't come right out?
Right. She said there are times where the pelvis might become entrapped, or the shoulder might become entrapped, the head might become entrapped. The cord, depending where the cord is resting, the cord could become entrapped. So it was all very much, these are things that could happen in a breech birth, but not, these are other ways that this particular breech birth could have gone.
And was there evidence that her life was at risk as a result of the breech birth?
Well, no. And Judge Agnes explicitly found that she did not remove the baby from her body in this way, either to save her own life or the life of the baby. And there was no evidence
Yes, there
about
was no
her
risk.
life
There was no
being
risk
in
to
this.
her at that point in time?
Well, you asked if there was evidence that there was risk to her life, and there was not.
He found there is no evidence that her life was in danger.
That's-
I just read his findings.
That's right. There was no evidence of that. Because the evidence viewed in the light most favorable to the Commonwealth sustained the verdict, the Commonwealth would ask the court to affirm the conviction.
Let me just ask you one other question. There was, your sister said earlier that she believes she was experiencing a miscarriage, and Judge Agnes found there is no evidence that she believed that the baby was already dead. What was the evidence that there was evidence, I take it, that she believed she was miscarrying?
She told the officers in the interview that she thought she was only 3 months pregnant and that when she was having contractions, she thought she was having a miscarriage. But Judge Agnes said that he did not credit that evidence, that she thought she was having a miscarriage. He did not credit that she thought she was only 3 months pregnant. Thank you.
All right, thank you. We'll take a brief recess.